Hello everyone, myself Dr.Rajashree Jawale, Assistant Professor, DG College of Commerce, Satara. Dear students, today we will discuss about remedies for breach of contract. A contract creates rights and obligations of the parties. The parties have to perform their respective obligations, but when one of the parties repudiates the contracts by refusing to perform it, he is said to have committed a breach of a contract. In case of a breach of a contract, the law provides following remedies to an injured or aggrieved party. So all these remedies are essential on the breach of contract. So first is rescission or cancellation, second is restitution, third is specific performance, fourth is suit for injunction, fifth is suit for damages. Damages is nothing but the compensation. So let us discuss these remedies in detail. First we will discuss about rescission or cancellation. In case of rescission, when one party commits a breach of contract, the other party may sue, that means to file a case, to treat the contract as rescinded or cancelled and refuse further performance. In such a case, he is relieved from all his obligations under the contract. The court may give rescission in some cases. 1. Where the contract is voidable by the plaintiff. 2. Where the contract is unlawful for causes not apparent on its face and the defendant is more to blame than the plaintiff. The court may refuse rescission in case of the plaintiff has expressly or impliedly ratified the contract. Second, where owing to change of circumstances, the parties cannot be restored to their original position. And third, where third parties have, during the subsistence of the contract, acquired rights in good faith and for value. And last, where only the part of the contract is sought to be rescinded and such part is not separable from the rest of the contract. So in all these cases, court may refuse to cancel the contract. Now we'll see second remedy, that is restitution. Restitution means an act of restoration. According to Anderson, a person who has been unjustly enriched at the expense of another must make compensation or restored him back with the benefit received. The principle of restitution applies in case of voidable contracts, in case of contracts becoming void, and in case of agreements discovered to be void. So here the right of restitution is not available if the agreement is known to be void. Party who has returned the benefit is minor and where party is required to give some earnest money which serves as a security for performing the contract by the promisor. Now we'll see third part, and that is specific performance. And damages means compensation. Damages may not be an adequate remedy in certain cases of breach of contract. The court may direct the party in breach to carry out his promise according to the terms and conditions of the contract. These are the directions by the court for specific performance of the contract. At the suit by the injured party, that means when the injured party will file the case in the court of law, at that time that person will have this kind of remedy of specific performance under the Specific Relief Act 1963. The court may grant specific performance in the following cases. 1. When the compensation in terms of money is not adequate relief. 2. When there is no standard for ascertaining the actual damages caused by non-performance. 3. When it is probable that the compensation in money cannot be received for the non-performance of the act agreed to be done. Now we'll discuss about fourth, that is suit for injunction. Injunction is one remedy which the court grant in civil cases. Where party is in breach of negative terms of a contract, that is, where he is doing something which is promised not to do, the court may, by issuing an order, restrain or prevent him from doing what he promised not to do. So, injunction is an order of the court to do or not to do something. So, court may give that kind of order. Such a prohibitory order of the court is known as injunction. The grant of an injunction by the court is normally discretionary, but there seems no reason why the court should refuse to grant an injunction to restrain or prevent a party from committing a breach of the contract. Next is suit for damages. A person who commits a breach of the contract must make compensation to the injured party. A monetary compensation awarded to the injured party is termed as damages. The primary purpose of awarding damages or compensation is to put the injured party in as a good position as he would have been if perform had been rendered as promised. Damages for the breach of contract are meant to compensate the injured party so far as money can do so. Now we'll talk about types of damages. So these are the types of damages: general or ordinary damages, special damages, vindictive or exemplary damages, and fourth one is nominal damages. We'll see first damages, general or ordinary damages. General damages are those which arise naturally in the usual course of things out of the breach of the contract. This means that the damages must be the proximate consequence of the breach of the contract. These are the damages which law takes for the granted from the breach of the contract. They are assessed on the basis of actual loss suffered. We'll see one example. Suppose A promises to sell and deliver to B 100 quintals of wheat at price rupees 900 per quintal to be paid on delivery. A commits a breach of contract. As a result, B has to purchase the wheat from the market at the rate of rupees 1000 per quintal. Thus, B suffers loss of rupees 10,000. He therefore can recover his amount from A. Now we'll see special damages. Special damages cannot be claimed as a matter of right. These are the damages which arises as a result of the unusual circumstances affecting the plaintiff. These are the damages which the parties knew at the time of making the contract. If the parties had no knowledge of the special loss they would suffer due to breach, such loss cannot be recovered by the other party. Now third, vindictive or exemplary damages. What is this? So here, damages are given for loss suffered due to the breach of contract by way of compensation. The idea is not to punish the wrongdoer or a person breaking the contract. Hence, vindictive or exemplary damages have no place in the Contract Act, but there are two exceptions to the rule. One, breach of promise to marry, and second, dishonor of a check by the banker wrongfully when there are sufficient funds in customer's account. The rule is smaller the check, greater is the insult. So here we need to understand that the damages will get only when there is actual breach, and if it is proved, if it is possible to recover, then only damages may be granted. So here In a contract, remedy on breach of contract is very essential, and court can give justice by giving a remedy. So here if we are talking about exemplary also called punitive or vindictive damages. Exemplary, that is punitive, that means the punishment. This is intended to show the court's strong disapproval of the conduct of the defendant in committing the wrong. So here they are not proportionate to the actual pecuniary loss sustained by the aggrieved party, but are inflicted by way of punishment. Now we'll see other part, and that is nominal damages. When the injured party does not suffer any loss due to the breach of the contract, the damages recoverable are just nominal. Such damages merely acknowledge that the plaintiff has proved his case and won. For example, suppose A promised to purchase a Hero Honda motorcycle from a local dealer, but he failed to purchase it. However, the demand for this motorcycle is constant, and hence the local dealer can sell the motorcycle without loss of profit. The dealer is entitled only to nominal damages. Now we'll see measures of damages. Measure of damages. The basis for the measurement of damages for the breach of the contract, both in India and England, this is found in a very important case. In the judgment or a decision of the case Hadley versus Baxendale. The fact of the case we will see. So measure or damages, that means measuring the damages or counting the damages or loss suffered by the parties. So here we'll see the fact of the case. X floor mill stopped working by the breakdown of the crankshaft, a part of the machine. He delivered the shaft to Y, a common carrier, to deliver it to the foundry, where the new shaft was to be made. Y promised to deliver it within 2 days, but he delayed and the mill stopped working for another 5 days. X received the new shaft 7 days later than they would have otherwise received. X brought a suit for damages against Y for the delay in the delivery of broken parts, and also for the loss of profit suffered by the mill as it stopped working. X had never informed Y that the delay would result in loss of profit. The court held that X was entitled only to ordinary damages and not for the loss of profit caused by the stoppage of mill during the period of the delay. So, the principle laid down in this case, the title of the case is Hadley versus Baxendale. So, the measurement of damages laid down in this case, where two parties have made a contract with which one of them has broken, the damages which the other party ought to receive in respect of such breach of contract should be either such as may fairly and reasonably be considered arising naturally, that is, according to the usual course of things from such breach of contract itself. This reasonably be supposed to have been in the contemplation of the parties at the time they made the contract as the probable result of the breach of it. Section 73 of the Indian Contract Act deals with the principles regarding the measure of damages based on the judgment of Hadley versus Baxendale. So there are rules regarding damages. Rules regarding damages. First, the injured party is entitled to be played in the same position as if the contract had been performed by giving him adequate compensation. Second, the injured party who suffers by the breach of contract is entitled to only such damages which arise naturally in the usual course of things out of the breach of the contract. And third, the damages are not awarded only in a remote or indirect losses suffered due to the breach of contract. Thus, a loss of business to the passenger due to train arriving late is too remote and therefore cannot be claimed. Fourth one, where a party claims special damages, he must prove that the other party knew at the time of making the contract that special loss was likely to result from the breach of contract. Fifth one, a person who claims damages should have performed or should be ready to perform his part of the contract. Sixth, a person who sues or files a case for damages should take all reasonable steps to mitigate the loss and should not allow to accumulate it by his own inaction. 7. When the parties agree about the damages for the breach of the contract, no more than the agreed amount can be awarded. Next, vindictive or exemplary damages are not awarded for the breach of the contract except in case of breach of contract of marriage or wrongful refusal by the bank to honor customers' check. Ninth, the compensation awarded for the quasi contract is the same as the breach of the contract. 10th, the court must make assessment of the loss. The difficulty in calculating the damages cannot be a ground for refusing damages to the aggrieved party. 11th, the aggrieved party is entitled, in addition to damages, to get the cost of the decree for damages. The cost of suit for damages is in the discretion of the court. That means court will decide the damages. And finally, if the sum of the damages is specified in the contract in case of breach, the aggrieved party is entitled to receive reasonable compensation not exceeding the amount so specified under the contract. So these are the rules of damages. So for this particular topic, I have referred Iganekosh, Dr. J. Chowdhury's book on Business Regulatory Framework and Indian Contract Act by Avtar Singh. Thank you.